In the summer of 1989, the gilded community of Beverly Hills was rocked by a crime so brutal it left the residents shocked and in fear. Things like this simply didn't happen in 90210. José and Kitty Menendez lived in one of the most exclusive neighborhoods of a city that seldom experienced anything like murder. Certainly not a wealthy couple being shotgunned to death while they quietly sat on their couch in their own home watching television. But what would initially remain a local scandal would turn into a worldwide phenomenon when the men arrested for their murders would turn out to be their own sons, Eric and Lyle Menendez. Please join me for this special episode of Courtroom Confidential, 5 Things You Need to Know, the Menendez Brothers. There is no shortage of coverage about the Menendez case. Literally, thousands of articles and books and documentaries and dramatized series have come out about this case. This year alone saw a wildly popular Netflix series and several more documentaries, all hoping to provide some sort of new perspective on a case that continues to fascinate us over 30 years later. But while a lot of focus on this case goes towards the murders or to analyze the motives of the brothers themselves, we felt that something often goes overlooked. What were the legal issues that undergirded this case? What you are about to learn may surprise you. Number 1. What happened? On August 18, 1989, Lyle and Eric acquired Mossberg 12-gauge shotguns along with boxes of birdshot and buckshot ammunition at a Big 5 sporting goods store in San Diego, California, where Eric used a stolen driver's license from one of Lyle's friends. 2 days later, on the evening of August 20th, 1989, José and Kitty were watching television in the den of their Beverly Hills mansion when Lyle and Eric entered the den carrying loaded shotguns. José was shot 6 times, including a fatal shot to the back of his head. Kitty was shot 10 times in total. Before the fatal shot to her cheek, she was on the ground, crawling away. Lyle ran to the car where Eric handed him ammunition to reload before firing the fatal shot to her face. Immediately after the killings, both brothers remained in the house for a few minutes, expecting the police to respond to the noise of the gunshots. They later left to dispose of their clothes that were stained with blood, then discarded the shotguns somewhere along Mulholland Drive. In between these, they also went to a movie theater and attempted to purchase tickets for the film Batman to use as their alibi, but abandoned the plan due to the timestamp on the ticket stub. They then headed to the Taste of LA, a festival at the Santa Monica Civic Auditorium. After returning home and finding no police presence, Lyle called 911 to report that his parents had been killed by unknown perpetrators. When the police arrived, they did not see gunshot residue tests from the brothers, which would have indicated that they had recently discharged a firearm. Detectives initially suspected the crime to be mob-related due to its heinousness and José's business connections. Police officers and forensic staff who worked on the crime scene described it as the most brutal one they had ever encountered, noting the blood and brain matter splattered throughout the room. In the months after the killings, the brothers spent lavishly in luxury items, businesses, and travel, including, infamously, 3 Rolex watches and a Porsche Carrera sports car. At one point, they attended a New York Knicks basketball game, which became immortalized when they appeared courtside in the background of a Mark Jackson trading card. Collectively, they spent approximately $700,000 before their arrests. As the investigation continued, police began to suspect the brothers due to the possible financial motive and their spending spree after the killings. Eric's high school friend, Craig Signorelli, reported to the police that Eric confessed to him. He also revealed that he and Eric had previously written a 66-page screenplay entitled Friends, which depicted his son killing his wealthy parents for their inheritance. Eric eventually confessed to his psychotherapist, Jerome Oziel, who then told his mistress, Judalon Smith. Oziel recorded his sessions with Lyle and Eric. After breaking up with Smith, she, in a fit of rage, informed the police about the brothers' involvement in the murders. Lyle was arrested on March 8, 1990, outside their Beverly Hills home, while Eric turned himself in 3 days later after returning to Los Angeles from Israel. Number 2, why did the confessions come in? A lot of discussion has been made about the fact that probably one of the most significant pieces of evidence was the confessions that the brothers made to their therapists. How possibly could a confession to a therapist come into a criminal case? Isn't that privileged? Let's talk about privileges. Privileges exist because we want to encourage the free communication in certain types of relationships. Certainly between an attorney and their client, between a husband and their wife, and yes, even between a psychotherapist and a patient. According to Evidence Code Section 1014 of the California Evidence Code, it provides that you have the right not to disclose any confidential communications between you and your psychotherapist in a criminal jury trial, and you have the right to prevent your therapist from disclosing any such confidential communications. We might think of some examples where this could be used. If a man is charged with rape, he is not required to tell about perhaps discussions about his violent sexual fantasies that he had discussed with his therapist, and the therapist would not be compelled to testify to those things. Or if a woman is charged with killing her husband, who had allegedly been abusive toward her, that woman's social worker or therapist who had counseled her also would not be required or forced to testify or tell prosecutors anything about those sessions without permission from the woman or defendant in this case. So how possibly did the confessions made to José in the Menendez case play such a pivotal role in their trial? Well, as with most privileges, there is an exception. The California psychotherapist patient privilege is not unlimited. The exceptions exist where, one, in cases where the defendant chooses to make their mental condition an issue by pleading either guilty by reason of insanity or claiming that they are not competent to stand trial. You could see where this would be the case, that someone cannot hide behind the shield of their psychotherapist privilege and at the same time claim that they are suffering from some sort of mental disease. Or two, cases where the defendant sought or used the psychotherapist's services to enable anyone to commit a crime or to escape being caught or arrested after committing a crime. Again, you can have a privilege, but that doesn't mean that you can use that privilege to further some sort of criminal enterprise. And lastly, in situations where the psychotherapist reasonably believes that the patient's mental condition makes them dangerous to either themselves, to someone else, or to someone else's property. On October 31st, Eric allegedly requested that he and José go for a walk rather than meet in his office because he was feeling extremely agitated and depressed. During their walk, Eric told José that his father was a great man and he wanted to write a book about him. They then walked back to the office, and before they entered, Eric told José, quote, "We did it." He went on to describe that they developed a plan to kill their parents because of how tyrannical, domineering, and controlling José was. Kitty also had to die, he allegedly said, because she wouldn't be able to live without her husband. Lyle soon joined the sessions, with the two confessing that they killed their mother to put her out of her misery, and that their father deserved to die for participating in infidelity that led to the misery. After about an hour, Lyle told Eric they were leaving, adding he would no longer speak with José. Just before stepping into the elevator, Lyle allegedly shook hands with the doctor and wished him, quote, "good luck," a gesture José later interpreted as a threat. In August 1990, a judge ruled that the tapes were admissible evidence because José stated that Lyle had threatened him and broke the doctor-patient confidentiality privileges by doing so. The ruling was appealed and the trial was delayed by 2 years. By August 1992, the Supreme Court of California ruled that most of the tapes were admissible, with the exceptions of the one in which Eric discussed the killings. Some of the content was considered outside the privilege due to the dangerous patient exception. Additionally, other parts were ruled not privileged because the court found that the discussions between the psychologists and the brothers took place in sessions that weren't intended for therapy. Now, you may be asking yourself, was this decision correct? Was this a miscarriage of justice to allow what many people widely believe should be a very secret and privileged communication between a patient and their psychotherapist, for that to be not only made public, but used in such a central role in that person's own criminal case? And the answer is perhaps. Even to this day, this is a hotly debated topic. But would they have eventually been apprehended anyways? The answer to that is also probably likely yes. They had made other confessions. It seemed as though the police investigation was starting to zero in on the brothers. In fact, by the time they even became aware of these tapes, the police knew about the purchase of the shotguns. But there's no getting around the fact that the confessions were a game changer. Remember, there was no gunshot residue found on the brothers because no one thought to look for it. The shotguns were never recovered. There was no forensic evidence linking the boys to the crime because of the way that police responded to this and the way that they initially investigated it. The boys were never seen as suspects initially, and therefore the usual type of forensic investigation was simply not conducted. And yes, it's true that perhaps with the purchase of the shotguns and the motive theory that the prosecution initially had, that may have carried the day. But think about how fundamentally these confessions changed the dynamic and landscape of this case. Without those confessions, this case may have been a whodunit type of trial. They may have been able to argue that they were not responsible, that someone else, perhaps a mob hit, the original suspicion of the investigators involved, was still the people responsible for this murder. And with little forensic evidence connecting them to it, the brothers could not be held responsible beyond a reasonable doubt. But because of those confessions, this case turned into what we know most about it to this day, which is being a what was it type of crime. Which brings us to number 3. What is imperfect self-defense? It's important, I think, to remember that this case was never about guilt or innocence. It was about what are they guilty of. Remember, the defense never argued to walk these men out the back door as free men. They asked for them to be held responsible, but just not for murder. And the theory that they were using to argue to the jury was the idea of imperfect self-defense. Imperfect self-defense is a legal concept that arises in California murder cases, and it applies when the accused kills another person based on an honest but unreasonable belief in the need to use deadly force in self-defense or defense of others. And in doing so, if a jury finds that the accused acted in imperfect self-defense, the results are that the charge is reduced from murder to voluntary manslaughter. Instead of facing life in prison, or in this case, even the death penalty for a murder conviction, the defendant would face manslaughter sentencing, which can reduce a person's prison exposure to the single digits. And the question really becomes whether the accused person's belief about the need to use deadly force was a reasonable belief. Would a reasonable person have acted the same way in the same position as the accused? If so, the defense is complete or perfect and warrants an outright acquittal. But if the defendant's belief is unreasonable, then the defense is incomplete or imperfect. As long as that person can demonstrate that they had an honest belief, yet falling short of being reasonable, it's considered qualifying for an imperfect self-defense instruction. The person is still found guilty of a very serious crime, but most importantly, not first-degree murder. The California Supreme Court, in the case of People v. Flannel in 1979, drew out some guidelines for this. A person is seen to act in imperfect self-defense, where 1, the person believes themselves or others to be in imminent peril of being killed or suffering great bodily injury. 2, the person believes that the immediate use of deadly force is necessary to defend against that danger. And 3, at least one of these mistaken beliefs is unreasonable. Let's consider an example. If a person is driving down the road and somebody else cuts them off, and that other person is making rude gestures towards them, and they see that person reaching around in their vehicle for something, and the driver of the vehicle who was cut off believes that they are going to be shot at, grabs their own firearm, and shoots and kills the other driver. The doctrine of imperfect self-defense could apply in this case in a couple of instances. First, if a jury was convinced that the defendant driver, the shooter, thought that that person was reaching for a gun, honestly, then the jury may be convinced that that was an honest belief, but unreasonable given the circumstances. Or if a jury instead finds that they actually were in reasonable danger, but it was unreasonable to fire back with a weapon instead of simply stopping their vehicle or driving away, that again would be an unreasonable response and therefore qualify for imperfect self-defense. This becomes incredibly significant for the Menendez case, because in the first trial, both juries, remember both Eric and Lyle had separate juries in that same trial, were hung on this exact issue. None of the jurors voted for an out-and-out acquittal in the first trial. But the evidence of abuse, the idea of imperfect self-defense, and the charge of voluntary manslaughter being available to the jurors obviously played a role, and that they were nearly split evenly on both juries between the idea of first-degree murder and voluntary manslaughter. This brings us to number 4. What changed at the second trial? That's a great question. What changed? Well, essentially, the world as many people knew it. In January of 1994, both of the juries on the Menendez case deadlocked. In June of that very same year, Nicole Brown Simpson and Ron Goldman were murdered. The O.J. Simpson trial begins in January of 1995, and he is acquitted just 10 months later on October 3rd of 1995. A mere 8 days later, the opening statements for the retrial of the Menendez brothers begins on October 11th. To say that that trial, the O.J. Simpson trial, did not have an impact both culturally and certainly within the legal community on how high-profile murder cases were prosecuted, I think is ignoring a lot. But other things change. They went from 2 juries to a single jury. The judge presiding over both trials was Judge Stanley Weisberg, and he ruled that the brothers would be retried together in the second trial in front of a single jury. He ruled that the advantages of a single trial greatly outweighed the potential prejudice to the brothers. There was a prejudice that could have existed if the brothers gave either contrasting legal arguments or gave statements that the other brother could not impeach through cross-examination. The judge felt that those issues or potential issues were outweighed by the quote-unquote advantages of having a streamlined single jury trial. Also, there were no cameras. Judge Weisberg ruled that the trial would not be televised because it would, quote, increase the risk that jurors would be exposed to information and commentary about the case outside of the courtroom. Again, if you don't think that what happens outside of a courtroom has an impact inside of a courtroom. Think again. Also, there was a new prosecutor. For the retrial, David Kahn, a veteran DA, replaced Pam Bazanich as lead prosecutor. Kahn had 18 years of experience and was acting head deputy of the Major Crimes Unit of the Los Angeles District Attorney's Office. The Major Crimes Unit is the most elite unit in the DA's office of Los Angeles, handling all high-profile cases, including the O.J. Simpson case and the Menendez case. During the 2.5 years between trials, Kahn studied the mistakes made by the previous prosecutors to make sure he did not repeat the biggest mistake of the first trial as perceived by the DA's office in their decision to not address head-on the brothers' allegations of years of physical, emotional, and sexual abuse. The original prosecutors essentially ignored it all, guessing incorrectly that jurors would too. Kahn vigorously attacked the defense theory that the brothers suffered from battered person syndrome and argued to the judge that the defense should not be allowed to present this theory to the jury. And it worked. In the second trial, the judge tremendously limited any arguments on abuse, on battered persons theory. No imperfect self-defense instruction was given, and no option for manslaughter was presented to the jury. During the first trial, 101 witnesses testified. During the retrial, that number was dramatically cut down to 64. Ultimately, Judge Weisberg limited 56 defense witnesses that appeared previously, precluding even the boy's cousin Diane, who had testified that Lyle had told her of his father's abuse at nearly 8 years old. In fact, all Menendez family witnesses critical of Jose were disallowed. Why did the judge do this? The judge reasoned that there was not substantial evidence that either Lyle or Eric believed they were in imminent danger, and therefore no requirement that the imperfect self-defense instruction be given. With that said, any evidence offered by relatives of the alleged abuse would have served only to explain why Lyle and Eric might have actually feared their parents. But without the imperfect self-defense instruction being available, the evidence ultimately was irrelevant, and the proffered evidence would likely have served only to confuse and mislead the jury. In the end, for the second trial, the jurors were left with little evidence of the boy's abuse aside from the testimony of Eric himself. No clear direction was given to the jurors of what to do with that evidence because no imperfect self-defense instruction was given, and they were only left with the choice of an out-and-out acquittal if they decided that the defense case was in fact convincing. When the choice came down to murder in the first degree for the shotgun killing of 2 people that the defendants themselves admitted to, or nothing, the choice was clear. Number 5. What is the Habeas Corpus petition? On May 3, 2023, Eric and Lyle filed a petition for writ of habeas corpus. Coming from the Latin term for "you should have the body," a writ of habeas corpus is a legal petition presented to judges in criminal cases by inmates in custody where they are challenging their conviction or sentencing conditions. Essentially, it is a prisoner's last chance effort to challenge their criminal conviction or sentence after exhausting all potential appeals in their case. Of the few examples where a habeas petition will be allowed include claims of new evidence discovered in the case. The habeas filed by the Menendez brothers outlines 2 new items of evidence they believe qualify. First, Jose Menendez's younger sister, Marta Cano, discovered a letter that her son Andy received from Eric approximately 8 months before the August 1989 shooting. In it is this quote from Eric: "It's still happening, Andy, but it's worse for me now. I can't explain it. He's so overweight that I can't stand to see him. I never know when it's going to happen, and it's driving me crazy. Every night, I stay up thinking he might come in." The second piece of evidence stems from the time that Jose Menendez was a high-level executive at RCA in the 1980s. During that time, RCA signed Menudo, a Latin boy band. Roy Rossello, who joined the band as a 13-year-old in 1983, has recently come forward to admit that he was sexually assaulted on multiple occasions by José Menendez when Roy was only 13 or 14 years old. But the real problem, and the nuanced legal issue to understand, arises from how this new evidence is seen in light of what the prosecution was permitted to argue during the second trial. The prosecutor told jurors the following things: that the sexual abuse allegations in this case were a total fabrication, that there was no way of corroborating these allegations, that the abuse never happened, that there is no corroboration of sexual abuse, that the allegations of physical and sexual abuse are not corroborated, that, quote, José Menendez was not the kind of man that would be abusing his sons. And in fact, he was restrained and forgiving and not a violent and brutal man. You can see how problematic this is. It is one thing for a judge to make decisions about what evidence can and cannot come in. But it is another thing to entirely ignore or misrepresent what the universe actually is. The prosecution may not have believed this evidence, and the prosecution may have felt that the evidence was fabricated. But to say that the evidence simply does not exist to the jurors without any way for the defense to fire back or impeach that, I think was a miscarriage of justice. In early October of 2024, Los Angeles County District Attorney George Gascon addressed the public in response to the habeas filed the year before and amid a social push and response to the Netflix series for his office to re-examine the convictions of Eric and Lyle Menendez. According to Gascon, I want to be very clear. We have not conceded one way or the other, he said. We're not saying there was anything wrong with the original trial. We have been given evidence. He went on to add, we are not ready to say that we either believe or do not believe that information, but we're here to tell you that we have a moral and ethical obligation to review what is being presented to us and make a determination based on a resentencing side. So as things stand right now, these are the following options. The district attorney could oppose the habeas, making it highly unlikely it will ever be entertained. The district attorney could submit to the habeas, leaving it in the hands of the court to make their decision, again, likely making the chances for release for the Menendez brothers very low. Or the DA actually has the power himself to request that the court have the Menendez brothers resentenced from first-degree murder, where they're currently serving life without parole, to voluntary manslaughter, where essentially they would have time served and be released. We hope that this episode has brought some new perspectives to this widely covered case. It remains unknown what the future holds for the Menendez brothers, but we are grateful for the time that you have taken with us to discuss this incredibly important case. Thank you for joining me for this special episode of 5 Things You Need to Know from Courtroom Confidential.